Hello everyone. The law of evidence is the most important law, which is an adjective law or a procedural law. The Evidence Act of 1872 is an exhaustive piece of legislation. Let us look into a overall summary of this or a overview of this act. First of all, the Indian Evidence Act codifies the rules of English law of evidence. It applies those rules as according to the peculiar circumstances of India, making such modifications as are necessary to our Indian situations. What is the object of this law? To prescribe rules, first of all, for the evidence to be admissible before the courts and on the issues before the court, for which issues the courts have to record the findings. That is the first object. The second object is to see that the evidence should be admissible, but there should not be laxity or delay in deciding whether the evidence is admissible or not. The rules are clear. Looking at these rules, we can easily help the judges or assist the judges to find what is admissible and how to see that that evidence is taken in that particular case. The third one we can say is that earlier there were a lot of different rules of practice relating to evidence, and the judges had a lot of difficulty in that manner. Now, a more correct and uniform rule of practice has been introduced by this act so that it is easier for the courts to decide on the case and to see that they apply the laws of the land to the facts of the case depending on these rules or following or applying these rules of evidence. Now, there are some principles which are evident when you look at the Evidence Act. You can find out that there are three main outstanding principles of this law. First of all, the main thing is, or the most important thing is, whenever an evidence is presented before the court, that evidence must be confined only to the matters in issue and no other matter. That means it should be relevant to that and only the relevant facts has to be put before the court. The second principle is that evidence should always be direct. It should not be hearsay. Whatever a person has seen by his eyes or heard by his ears or he has actually witnessed it, only those things can be presented before the court. He cannot say something before the court as evidence which he has heard from somebody. So hearsay evidence will not be admitted except according to some exceptions which we will be discussing in this act in this overview. Now the third principle is that best evidence must be given in all cases. So the evidence which is available, the court has to separate the different facts before it and see that only the best evidence has to be admitted. That is a very, very important rule of evidence. Now let us look into the scheme of the Evidence Act. This Evidence Act is divided into three parts comprising of 11 chapters. The first part basically speaks first of all of the scope of the act, the definitions and the relevancy of facts. So this is a most important part we can say, and it is also called as a substantive part. The second part comprises of chapter 3 and 4, which provides for proof of the facts by oral or documentary evidence, because the facts are relevant, but once they are presented before the court, they have to be again proved. That is stated in part 2. The part 3 comprises of rules for how the evidence has to be produced before the court and what are the different presumptions under the law, what is the effect of presumptions and the duties of the court relating to those presumptions. For example, if something is presumed to be a fact, then the court will not allow us to present any evidence for that particular matter, or if you challenge that presumption, then you can rebut that presumption, and if the court is satisfied, the presumption will be rebutted. So these things are stated in part 3. It also speaks about the main important duties of the court when it deals with the evidence produced before it. Let us come to chapter 1. First of all, chapter 1 speaks about the definition of different terms which are mentioned in this act. The relevancy of fact is one important chapter that stretches from part 1, that is relating to facts, relating to the definitions and relating to the relevancy. So fact means what? What is the definition of a fact? First of all, fact means anything, state of things, or relation of things capable of being perceived by the senses. We have 5 senses. Whatever is perceived by the senses only is a fact. Also, it includes any mental condition of which any person is conscious. These are the actual wordings in the Evidence Act. Now, when we speak of facts in issue means any fact from which either by itself or when that fact is connected with some other facts which are brought before the court, in any suit or proceeding before the court, the nature or extent of any right, liability or disability which is asserted by one party or denied by the other party necessarily follows. So, how can we explain this? First of all, fact is anything. So, if a thing is seen by a person, it is a fact. If a person hears something, it is a fact. If a person thinks of something, it is a fact. But only if that fact is connected with the facts before the court, which is there, or which is an issue before the court, then only it is called as a fact in issue. Now, the third definition is a relevant fact. What is a relevant fact? A relevant fact is that when one fact is given and that fact is connected with another fact, and that connection is according to the chapter of the relevancy of facts in this Evidence Act. Section 6 up to 55 speaks about what are the different circumstances in which facts are relevant to each other. So, only when the facts are connected in that manner, then only it is called as a relevant fact. That is the definition provided. Now, let us define what is evidence. Evidence is defined in a very clear manner, or we can say in a simple manner in this act. Evidence means and includes. Actually, when we define evidence, we can define it in many ways. But here it speaks only of two kinds, oral evidence and documentary evidence. It says all statements which the court permits or requires to be made before it by witnesses in relation to the matter of fact under inquiry. That means if there is a matter before the court and the witnesses come before the court and make a statement, it is not that the court will allow all the statements, but when the court asks something to be put before the court, or it requires, or it allows or permits, then that statement is called as oral evidence. Then what is documentary evidence? All documents, including electronic records. These words have been inserted by way of amendment in the year 2000. All documents, including electronic records, produced for the inspection of the court is documentary evidence. So, when we see this definition, we find that it is not stating anything about direct evidence or circumstantial evidence or kinds of evidence or primary evidence or secondary evidence. It only speaks of two things. Now, when we see which evidence should be given, evidence can be given of every fact in issue or of relevant facts. It is very simple. Only of facts in issue and relevant facts evidence can be given, nothing else. So, coming to the relevance of facts, that is section 5 to 55. What facts are relevant and what are those facts which can be presented before the court? Section 6 is very important. It speaks about the doctrine of res gestae, which means that even if a fact is not a fact in issue, but it is so connected with a fact in issue such that it forms part of the same transaction, then that fact is relevant. So, when we come to section 6, we see that there are so many facts which may not be connected to that particular fact, but it should be connected with a fact in issue before the court. It may not be part of the things which are presented before the court, but some connection is there between those facts and the fact in issue. So, it is a very wide particular provision, and what is res gestae has to be decided with reference to number of cases and with reference to the Supreme Court's directions and the Supreme Court's interpretation of this particular section. This is nothing but the English doctrine of res gestae. So, we can see that res gestae is the first section where there are certain things which may not be connected, but still it can be connected in some way, and that becomes a part of the same transaction. This was stated in Kundula Balasubramaniam versus State of Andhra Pradesh, where it was a case of bride burning, and the several facts which came before the court which were not actually the facts at that particular moment or at the time of a burning, but they were connected to that particular incident. They were taken as res gestae and the person was convicted. So this is res gestae. Coming to section 7, any fact which provides the occasion for the fact in issue, or it gives the cause of the fact in issue, or which provides for the effect of the fact in issue, or it provides a opportunity to the person relating to the fact in issue, or it shows the state of things which comprise the fact in issue. All these things are relevant under section 7. The next section, that is section 8, speaks about motive, preparation and conduct. So when a person does an act and the issue before the court is whether he is responsible for that act, then all the facts which provide the motive for that action or which provide the circumstances under which he has prepared for that action, or his conduct before that act or after the act, which is stated by witnesses or by other means of evidence, those things, they are all relevant under section 8. For example, if a person is accused for murder, then a thing which caused the murder, the occasion which he got, or the effect of that what has happened upon his mind. Suppose there is a quarrel between him and that person. So the effect of that upon his mind, that can be showed by facts. The opportunity which he got, he visited the person's house and he found that he is alone. So that is the opportunity. Or the state of things, that person was sick, so it was easy for him to restore or to give something to him so that it poisons him. Motive is the end result. So any fact which shows the motive of that person, what is going to gain out of it, or any fact which shows that he was preparing for that incident. For example, he goes and purchases the poison from the market, or his conduct, suppose people are talking about that and that person runs away. His conduct shows that that particular fact can be presented as a fact which is in connection with the fact in issue. So these all are relevant under section 8. Now coming to section 9. Here it is a very vague thing, but we have to understand this in a proper manner. Facts which are necessary to explain or introduce a fact in issue or relevant fact. For example, suppose a person is accused of a crime. Now, what is the fact in issue? Whether that particular crime has been committed by that person, whether he has an intention. Now, those facts which explain that, which introduce that person, who is that person, or what is that fact, or what is that thing which we want to put before the court, all those facts are relevant. Then anything which introduces the fact in issue or any relevant fact, that is all relevant under this particular section. Also, facts which support or rebut an inference suggested by such a fact. For example, we say that that person has committed the offense in a particular place. But if the fact is shown that he was at that time at a different place or at a railway station in some other place, and we prove the fact by giving an evidence of a ticket or of his identification at the airport or something like that, those facts rebut the inference which is suggested by that particular fact that he has committed the crime. So such facts which are supporting or rebutting that inferences which is suggested, that is relevant under section 9. Thirdly, any fact which establishes the identity of anything or any person, his identity should be relevant in that particular case. Then the fact which establishes that he is the person, for example, we speak of identification parades, they are all relevant facts, and that identification report and the report where it says that he is the person and the person identifies him, the victim identifies him, or anybody who has seen him at that time, these are all relevant facts. Then facts which fix the time or place at which any fact in issue or relevant fact has been occurred. For example, suppose you say that a person was available at a particular time in that place. But there is another piece of evidence which shows that he was at that time delivering a lecture in a hall, and there is a record of that. So it fixes the time. We can say that it rebuts. But suppose at the particular time you have a watch, or you have an alarm, or you have a stopwatch which has stopped at that particular time. That thing fixes the time, or it fixes the place. So such things are relevant to fix the time or place. It is relevant. Some facts which show the relation of the parties by whom such fact was transacted. So what is the relation of the parties? Suppose there is a transaction, or there is a agreement, or there is a particular fact which is an issue, and the one party is asserting, the other party is denying. Then the relation of the parties also can be relevant facts to show that this was a proper thing which was done by them. So under section 9, all these things can be discussed or can be presented. Coming to section 10, which is also very important, these relevant facts come to play when there is a allegation of a conspiracy. So when there is a conspiracy and the persons who are conspirators or alleged to be conspirators, those facts which prove that there was a common intention and there was a connection between these parties, as long as that particular transaction went on and there was a conspiracy, all those facts which show that will be relevant under section 10. This comes to play only when there is a offense of conspiracy to be proved. Section 11 speaks about inconsistent facts or probability. Suppose there is a fact which is inconsistent, or there is a fact in issue before the court, but some fact is there which shows that that fact is not possible at all, or something is there which shows that in all probability that is the fact which has happened. Then in such case, this section 11 speaks about the plea of alibi. That is, what is the reason that these facts should be taken. Plea of alibi is a part of section 11. The person is said to have done this act, but at the same time he was doing some other act. So there is a probability that he must have done it or he may not have done it. But when it shows that his alibi is completely foolproof, then the inconsistency of him committing or of that fact can be proved before the court. So this is section 11. This is particularly to prove that an accused was somewhere else at the time of the crime in a different place. This is section 11. Section 12 speaks about suits for damages. Every fact that would help the court to quantify the amount of damages or compensation that ought to be given or awarded in a particular case. All those things, all those facts which bring the court to assess the damages in that particular suit, they are all relevant facts. Section 13 speaks about rights or customs. For example, when there is a question of the existence of any right or custom and any transaction by which that right or custom was created or claimed or modified or recognized or asserted or denied, all these facts or some fact by which it can be proved that that custom or right was not in existence or it started at a particular time. All these facts are relevant under section 13. Section 14 speaks about facts showing the existence of any state of mind, body or bodily feeling. For example, what is the intention of the person? What was his knowledge? Did he have knowledge of his act? Did he do that in good faith? Did he act with negligence? Did he pronounce or show due care? Did he drive with rashness? Did he act with rashness? Did he have ill will towards the person? Or was it bona fide? All these things show the existence of the person's state of mind, or it shows that his body or bodily feeling has that particular characteristics. So this is the facts which are relevant. Sometimes it is necessary that the evidence produced must relate to the specific state of mind of a person. At that time, section 14 comes into play. Section 15 speaks about evidence of similar facts. Normally, similar facts are not considered as evidence. For example, if a person commits a crime in a manner and then he commits a similar crime at some other instance of the same kind. Can you say that he is the same person who has committed both the crimes? It's very difficult to say that, because sometimes it may bring in innocent persons also. But it helps when we see the modus operandi of the person who commits the same act in a particular manner again and again and again. So that brings us to come to a decision that he is the person who has done it and identify him. So in certain cases, this section provides exception to the rule that evidence of similar facts cannot be taken, it is excluded, but in these circumstances it can be relevant. Section 16 speaks about existence of any course or business. For example, if a thing is done according to the course of business, if I post a letter, evidence has to be shown to the court that I have posted the letter or I have sent it by registered post in the ordinary course of business. Those facts are relevant according to section 16 to show that that act in question must have been done. So, in section 17 to section 55, the statements which are relevant under certain circumstances are discussed. So, what are the statements which operate as relevant facts? Let us categorize them into several parts. First of all, admissions, confessions, or statements by persons who cannot be called as witnesses, statements made under certain circumstances, statements made by courts in judgments, statements made by third persons which is their opinion, and statements showing the character of parties. Coming to the first one, what is an admission? A statement which is oral or documentary or which is contained in electronic form, which suggests any inference as to any fact in issue or relevant fact is an admission. It does not say anything whether that admission is stated by a person or by whom or by a representative or by a party. It only says any statement. It may be oral or documentary, but that from that statement it should be known that that fact or that relevant fact or fact in issue has happened or it suggests that inference. So, such statement is an admission according to section 17. Again, section 18 speak about which parties' admissions are relevant. For that, it speaks about parties to the suit, agents of parties to the suit, or a party suing in a representative character who makes admissions, or a person from whom the parties to the suit have derived their interest. These are all stated in section 18. Section 19 speaks about a person whose position it is necessary to prove in a suit, and such statements would be relevant if that suit is brought in by that particular party himself. Then, a person to whom a party to the suit has been expressly referred for information in reference to the matter in dispute. Persons having pecuniary interest, proprietary interest, or whose position is in issue, or the person who is expressly referred to. All these statements of these persons are relevant under section 18, 19 and 20. Now, what is the difference between admissions and confessions? Confession is also a kind of admission, but the difference is that confession is an admission by a person who is charged with a crime. So, a person who is charged with a crime says something from which we can have an inference that the statement of that person itself suggests that he has committed the crime. Such a statement is called as a confession. Now, when is a confession relevant and when is it irrelevant? Because a person's confession is not foolproof. It may be obtained by an inducement or a threat or a promise. He must have been taken in custody and the police may have induced him, or they may have threatened him to confess, or they may give him some promise. A promise which may tell him that if he does this act, he will be able to get some advantage of a temporal nature. In such cases, that inducement or threat or promise must be referring to the charge in question, first of all. Secondly, the inducement or threat or promise must be proceeding from a person in authority. So, a person who is in authority must have given him that particular inducement. Then that confession is relevant according to section 24. Then a confession is relevant if where more persons are tried jointly for an offence. For example, there is an offence committed by two or more persons, and in those persons, one of them makes a confession which affects not only himself but also some other of those jointly tried people. Then that particular statement can be taken as a relevant confession against him and the other. This is explained in section 30. Next, let us go to section 32, which is also a very important provision. Sometimes the witnesses cannot come before the court, so their statements by witnesses who cannot be produced. For example, statements made by a person who is dead or who cannot be found or who has become incapable of giving statement. Statements made by a person who is dead, who cannot be found or who has become incapable of giving evidence or whose attendance cannot be procured without, according to the court, unreasonable delay or expenses. Then such statements, when it relates to the cause of the death of a person, or when it is made in course of business, or when it is against the interest of the person making it, or it gives an opinion as to the existence of a public right or custom, or it mentions the existence of any relationship between persons, and that relationship or that existence of the relationship is known by that person who makes that statement, and he has a special means of knowledge in such cases, or that statement relates to existence of any relationships between deceased persons. Suppose that statement is relating to something which is contained in a deed or will or other document. Of course, they cannot be produced before the court, but that deed, will or other document is relevant. Or if the statement relates to something or some matter which is made or which is stated by a number of persons, that means a number of persons together or separately, they make a statement which is relevant. They cannot be brought before the court for the several reasons which we have mentioned, but still that statement is relevant under section 32. Section 33 speaks about depositions in former trials. Whenever there is any evidence given by a witness in a judicial proceeding or before any person who is authorized by law to take it, for example, he may be a notary, he may be a administrative tribunal, or he may be any kind of tribunal which is a quasi judicial proceeding also. In that, suppose any evidence has been given, then such evidence is relevant in a subsequent proceeding or at a later stage in the same proceeding, but there are certain conditions. What are the conditions? The conditions are that that person or that deposition must be made when the witness is dead, or he cannot be found, or he is incapable of giving evidence, or he is kept out of the way by the adverse party, and it will be admissible only if that proceeding was between the same parties or their representatives, or if the adverse party in the first proceeding had the right and opportunity to cross-examine that party only, then only it will be relevant. And if the question in issue were substantially the same in both, in the earlier proceeding and in the later proceeding, in such cases, such depositions in formal trials are relevant. Coming to section 34 to 38, statements made under special circumstances. For example, entries in books of account are relevant. Entries in public record or electronic records which is made by a person who has entered them in performance of his official duty, all those entries are relevant. Statements which are made in maps or in charts, it may be by the government authorities, and plans. Of course, these maps, charts and plans should come from an authorized source, then only it can be relevant. Statement as to fact of public nature. For example, in certain acts or notifications, there are certain things given, some statements made. They are all relevant because they are special circumstances, and these special circumstances authorize the truth of that particular facts. Then, statement which is relating to any law which is contained in the law books. There are authenticated or proper books, or we can say law reporters or law theses, where in that books the statements are contained. All these statements can be given as evidence, and they are all relevant under these sections. Then whether judgments of courts are relevant. Normally one judgment is not relevant to any other party, or suppose there are two cases, one judgment passed in a case is not relevant to the other court, you cannot give it as an evidence. But there are certain exceptions here. What are these judgments of courts? Relevancy of judgments, opinion and character. They are from section 40 to section 53A. These are relevant facts of great importance. Why? Because they do not bind the parties to the suit or their representatives, but such judgments which are of a public nature, they are all relevant under certain conditions. Let us categorize them or let us classify them. Judgments operating as res judicata. For example, if a judgment is passed in a case, it becomes res judicata relating to those parties in the suit or their representatives. Such judgments, suppose they file another suit, then that can be given as a evidence showing that it is res judicata. Secondly, judgment in probate cases, matrimonial cases, admiralty cases or insolvency cases. Under all this, there are rights which are of a public nature and they are called as rights in rem. They are all relevant. The judgments which are other than those in section 41, they are all relevant under this particular section. Then also the statement can be given that in obtaining judgment, the fraud or collusion has been taken place, and if the fraud or collusion is there in obtaining a judgment, that matter also becomes relevant and it can be stated before the court. Coming to the next category, that is opinion of third persons. It depends on which are these persons. Who are these persons? First of all, section 45 speaks about what is this expert evidence. Who are experts? So experts are those people who are specially skilled in foreign law, matters of science, matters of fact or handwriting, matters of art or finger impressions. They are all stated under section 45. Section 47 speaks about what is the value of the opinion of a person as to handwriting. So in what conditions or what is the value of that particular evidence, it is stated in section 47. Section 47A speaks about opinion as to digital signature. So opinion of a person who is acquainted with the handwriting, his evidence can be given, or the person who is the certifying authority who has allotted this digital signature, his opinion is valuable or is it relevant under section 47A. Section 48 speaks about the evidence of persons who are giving opinion as to existence, as to right or custom. Suppose opinion of a person expressed in certain matters where he has a knowledge of the right or custom in that particular place. That is an opinion. It is not, he is not a party in the case, but it is relevant in that particular case. Section 49 speaks about opinion as to usages, tenets, rules which pertain to particular customs. These are all relevant under this section 49. Section 50 speaks about opinions of people expressed relating to relationship of one person to another. For example, a member of a family, he has a special means of knowledge of a person who is who was part of the family. So his opinion also counts. It is relevant under this section 50. Then there is a difference between civil cases and criminal cases. The next category of evidence which is relevant deals with the character of the parties. For example, character includes both reputation and disposition. Character affects both reputation and disposition. Relevancy of character may arise both in civil and criminal cases. In civil cases, character to prove conduct imputed is irrelevant. Normally, in civil cases, we cannot speak about the character of a person and say that he is a very good person and therefore there is no chance that he has committed this wrong. So in civil cases it is irrelevant, but there are exceptions to that, and these exceptions are stated in this particular provision, and it can be given only in criminal cases, but again there is a classification, good character and bad character. Normally previous good character of a person can be given, it is relevant. For example, if a person is of a good character, you can mention that evidence can be given, but his previous bad character is not relevant in a criminal case. You cannot say that he has committed an offense and previously also he had a bad character, he is a bad person, and therefore there is always a chance that he has committed that offense. That is not relevant. But if the other side, the adverse party, says something about his good character, then in reply to that or to rebut that, the person, the prosecutor, can say that he is of a bad character and the evidence can be given of the previous bad character. So, this is the important difference in civil cases and criminal cases. The part 2 or part 2 of the Indian Evidence Act speaks of proof of relevant facts. So, as we have seen what are the all relevant facts which can be put before the court, now how these facts are to be proved, that is stated in part 2. Section 52 to 58, it says that normally facts which need not be proved first of all, and then which are the facts which need not be proved and which are the facts of which court must take judicial notice. So, facts of which the court will take judicial notice is section 56, and section 57 gives 13 item list of facts which court is bound to take judicial notice and facts which are admitted. Chapter 4 speaks about the different modes of proof. Section 59 defines oral evidence, and section 60 says that all oral evidence must be direct. For example, oral evidence must refer to a fact which could be seen, it must be the evidence of a witness who says he saw it, or it must refer to a fact which could be heard, it must be the evidence of a witness who says he heard it. Or if it refers to a fact which could be perceived by a sense, then it should be the evidence of a witness who says he perceived it. So, it should be always direct. Section 61 to 98 explain about the admissibility of documentary evidence. What is a documentary evidence? So, documentary proof, section 61 to 98. Contents of documents, how they can be proved? Normally, they can be proved by two methods. One is by primary evidence, one is by secondary evidence. Now, as far as possible, primary evidence is important. But if primary evidence is not able to be produced before the court, then secondary evidence can be given. Now, in section 71 to 74, there are several lists about the documentary evidence, how they are to be produced. Public documents are described in section 74, and along with that, there are certain presumptions as to documents which is explained under section 79 to 90A. So, when it speaks of the presumptions as to documents, they provide for cases in which the court shall presume to be genuine certain facts about the documents, and the court is bound to accept those facts until and unless they are disproved. So, this is relating to documentary proof. Section 91 explains the exception to the rule that no evidence of any oral document can be given or shall be admitted relating to any documentary evidence between the parties to such document. For example, if there is a document, then that document only has to be produced and nothing else. Section 90 before that has spoken about a document which is 30 years old. Section 90A speaks about electronic records, but section 91 speaks about documentary evidence which has to be produced and no oral agreement can be given. So, exclusion of oral by documentary evidence. This is chapter 6. Then coming to the production and effect of evidence according to sections 101 to 167. This is part 3 of the Evidence Act. This part deals with the production and effect of evidence. It comprises of the question of burden of proof, the rules as to who is to give evidence and under what circumstances, the rules as to examination of witnesses, and the effect of improperly receiving evidence or improperly rejecting the evidence. What are these rules? So, first of all, burden of proof, section 101 to 114A. Section 101 says that burden of proof, that is, whoever desires any court to give any judgment as to any of his legal right or liability, and he has certain facts, and that legal right or liability depends on those facts which he is asserting, then that person has the burden of proof to prove that those facts exist. This is a very important provision. And similarly, we come to section 102, where again a different manner of burden of proof is stated. For example, it says the burden of proof in a suit of proceeding lies on that person who would fail if no evidence were given on either side. So we can say that section 101 speaks about burden of proof, section 102 speaks about onus of proof. So this onus keeps on shifting. Suppose a person says something, he produces a evidence, and then he produces some facts, and that is taken by the court, and the burden of proof shifts on the other person. Suppose he asserts something, he is successful to prove that, then the burden of proof or the onus of proof shifts on the other person. So that is section 102. If no evidence was given by both of them, suppose that case would fail for a particular person, then that person is bound to prove his case. The next part deal with presumptions. Section 111A to section 114A are the most important of these. And first of all, the presumption which rises is useful in this evidence, because the effect of presumption is that a party in whose favor a fact is presumed need not prove the case, he is relieved of the initial burden of proof. But if the other party proves the case, or he says that this thing does not exist, or that presumption is rebutted, then he has to prove it. The court presumes existence of the fact in his favor, and the court may also act upon it unless the other party shows the contrary. Then again, coming back to 111A, this is a presumption relating to certain offences. In certain places, when some offences are committed, for example, certain persons are presumed to have committed certain offences which are stated in sections 121 to 123 of the Indian Penal Code. Some disturbed areas, if a person is found, for example, with some firearms or some arms in his possession, then there is a presumption that he has committed an offence. Then the burden of proof lies on him to prove that he has not committed. Secondly, burden of proof in the case of marriage, birth during marriage. Section 112 says that if a person is born during a valid marriage between his mother and any man, or within 280 days after the dissolution of that marriage, and the mother remains unmarried, then unless non-access is proved, it shall be a conclusive proof of legitimacy of the child, and the court will not allow the person to give any other proof or any other evidence which rebuts that. It is a conclusive proof unless non-access is shown. Section 113A is another presumption. It is a presumption relating to abetment of suicide of a married woman. This is when a married woman has committed suicide within 7 years of marriage, and the fact is proved that, or it comes before the court that she was subjected to cruelty, that would create a presumption that the suicide was a result of abetment of suicide by her family members. Again, burden of proof lies on those family members to show that they have not abetted this suicide. Section 113B speaks about presumption as to dowry death. When a person has committed a dowry death, that is a question before the court, then just soon before her death, if that victim has been subjected to cruelty or harassment for dowry, then that person who was alleged to have subjected her to the dowry cruelty, he is presumed to have committed the particular offence or the dowry death. So this is a presumption. So the burden of proof again shifts to the accused to prove. Section 114 also speaks about general presumption in certain cases. For example, in common course of natural events, certain things are presumed, or in common course of human conduct, certain things are presumed. In public and private business, certain things are presumed. Or, for example, receiving stolen property. If a thing is there in the hands of a possession of a person and it is a stolen property, then the burden is on him to prove that he did not know that it is stolen. Or, for example, there is an accomplice, the testimony of an accomplice, or in the case of judicial and official acts, or withholding of evidence. Suppose a person does not bring to the court some document which he is asked by notice to produce before the court, then there is a presumption that that document must be against him. So, there are these certain lists of general presumptions under section 114. Section 114A speaks about presumption as to absence of consent in prosecutions for rape. Here, if the victim woman says in the court that she has not consented to the act, then the court would presume that there would be no consent or there was no consent. This shifts the consent or to prove the consent on the accused, and if he fails to do so, then there would be finding that he was guilty in that offence. This is section 114A. Again, there is one more concept of estoppel which is similar to the doctrine of estoppel in English law. That comes to section 115. When one person has by his declaration, act or omission intentionally caused or permitted another person to believe that something is true, and that other person, believing that thing to be true, has acted upon that belief, then later on this person who has declared or acted or omitted, he cannot be allowed in any other suit or proceeding to deny the truth of that thing. Suppose he has stated something, he has to stick to it. It says that once you say something, you have to stick to your point, you cannot go against it. But the condition is that the other person should have believed it and acted upon it. This is stated in section 115. Again, section 116 and 17 go to the details of the estoppel and kinds of estoppel. Then there is one chapter on privileged communications, that is section 122 to 126. Here there are certain privileges which are given to certain people who are not forced or not compelled to disclose certain things before the court, and they are privileged. For example, section 121 also, it says that a judge or magistrate cannot be compelled to answer any question as to his own conduct or as to anything which came to his knowledge as a judge or magistrate. Coming to section 122, actually they can be classified as two kinds of privileged communications relating to witnesses. One is which are privileged from disclosure, and the second is that is prohibited from being disclosed. That means if he wants to disclose also, the court will not allow him. Then coming to section 122, that is communication between a husband and his wife, a man and his wife. A man cannot be or a wife cannot be compelled to disclose anything which is made as a communication during marriage to the person to whom he is married or she is married, except when the suit is between married persons, or except in proceedings in which one married person is prosecuted for a crime against the other. Coming to 123, unpublished official records. No person can give evidence relating to unpublished state records relating to any affairs of state except by the permission of the officer at the head of the department. Section 124 says official communications cannot be disclosed, or no public officer can be compelled to disclose anything in official confidence if the public interest will suffer by such disclosure. Section 125 speaks about secrecy about the source of information relating to magistrate or police officer which they have to maintain. Then section 126 speaks about the privilege relating to communication between an advocate and his client. They cannot be asked to disclose that. So, these are the privileges. Next, we come to the examination of witnesses. What are the different ways of examination of witnesses? It is stated in chapter 10 from section 135. The order of examination as per civil and criminal procedural law is discussed. First of all, 137 says that the first examination of a witness by the party who calls him, it is called as examination in chief. Secondly, the examination of a witness by the adverse party is called as cross examination. Thirdly, the examination of a witness subsequent to the cross examination by the party who called him is called as re-examination. This is 137. Then there is a point that what are leading questions and when leading questions could be asked. Section 141 to 143. Section 141. What is a leading question? A leading question is any question which suggests the answer which the person who is putting that question is expecting to receive from that person. That is called as a leading question. Now, when it should be asked or when it should not be asked? Section 142 says that in examination in chief or re-examination, leading questions must not be asked. Section 143 says that it can be asked in cross-examination. Then, what are the questions in cross-examination? Section 145 to 154. First of all, cross-examination may be relating to any questions which tend to test the person's veracity or to discover who he is or his position or to shake his credit. So, they can be categorized in this form. Cross-examination as to previous statements in writing, and which are the questions lawful in cross-examination, and when the witnesses are compelled to answer, and how the court decides when he should be compelled. So, these are the ways how it is shown from section 145 to 154. For example, when we speak about answers or questions which are forbidden by the court decides when he should be compelled. The court will forbid any question which it thinks that it is indecent or scandalous or which refers to something which tends to be indecent or scandalous. Some questions which are improper questions and proper questions. The section 148 speaks about what is a proper question, what is an improper question. It also speaks about questions as to character. Sometimes the court may compel the witness to answer a question or may warn him that if he is not obliged to answer it. All these things are the duties of the court which are discussed in these particular provisions. There is also a provision relating to impeaching credit of the witness. The credit of a witness can be impeached by the following methods. For example, when he is unworthy of credit. For example, by the evidence of persons who testify. There are some other persons who come and testify that this person is believed to be unworthy of credit. So, that method can be used. Or it can be given as a proof that the witness has been bribed, or he has accepted the offer of a bribe, or he has received any other corrupt inducement to give evidence. That is also used to impeach the credit of the witness. Thirdly, former inconsistent statement of that witness which is made in any other part or in the part of that same case or in some other different context, they are all relevant and they can be asked to impeach the credit of the witness. Then there are certain cases where evidence in corroboration can be made. So, a person can be, the witness can be asked to answer certain questions to say something to corroborate. So, when a witness whom it is intended to corroborate gives evidence of a fact, he may be questioned as to what are the circumstances. So, all these are stated. Now, the final part is when we come to section 165, that is the power of the court. Actually, when the witness is asked certain questions and the judges record those questions or the judges take into consideration those facts, the judge has a complete power to put questions to that witness on his own. So, the judge has been given power under section 165 to ask any question to a witness or a party or to anybody in the court, and the court may also order the production of any document. The court may ask the person to produce something, and when the court asks to produce something, no party shall raise any objection to such question or order. Such witness shall not be cross-examined and as to any answer he may give before the court, but if a person wants to cross-examine, then he has to take the permission of the court. So, these are the things which are stated in section 165. Finally, the last section is section 167, which speaks about improper admission or rejection of evidence. It says that no new trial shall be ordered for improper admission or rejection of evidence. For there cannot be any ground for a reversal of a judgment or for a new trial of the case, but in that case, the court has to think that independently of the evidence which has been given, there was sufficient evidence to justify the decision, or if the rejected evidence has been received, it ought not to have varied the decision. If the judge thinks that if that particular thing was given or that particular admission of the evidence was done and it was done properly, the decision would have been different. Or if that evidence would not have been rejected, the judgment would have been different. In that case, there can be an exception. So, Section 167 speaks about these conditions. Reversal of a new trial can be ordered only if it appears that the improperly admitted evidence, if it had been rejected, or if that improperly rejected evidence would have been admitted, then the judge would have given a different decision. In that case, a new trial can be ordered. So, when we summarize the Evidence Act in itself, it deals with all the facts which are necessary to be admitted before the court as evidence. What are admissible, what are relevant. It says that these are the relevant facts. It discusses all the methods by which the facts can be proved, and finally it lays down the procedure for the production of the witnesses and examination of witnesses along with the rules for production of documentary evidence before the court. I hope you have learned something from this video. If you have liked it, please share it with anyone who you think would be interested. Please leave your comments and I would be happy to reply to them. Do subscribe to get more information on everyday law and legal studies. Thank you.